what I mean by that is my goal is to have every 24 hours it goes finds the most used keywords, the best thumbnails out there, how they're producing by the big, that's the big thing. So
yeah, no, I love it. I love it too, because you've talked about three different things, and this is, we're not in a legal strategy session. I'm not your attorney. Nothing here is legal advice, but it kind of highlights, or if we want, it lets us talk about some of the stuff we were talking about before, right? Like which of these types of things is potentially patentable and which probably aren't, like the last one. And this is just me off the cuff. I haven't done any research. The last one sounds like it's just aggregating a bunch of stuff that other tools already do. That one probably, unless you've got more to it that you're not talking about.
There is a little bit more. It's all AI though.
Yeah. So the way it's doing it and stuff like that, things where you're just aggregating into one platform, it's less likely to be patentable. But your trademark, branding, stuff like that might be super important. Whereas the AEO engine, you're kind of at the forefront of this new field. You're doing things that nobody else has done, either because they haven't thought of it or because you're just so early. You're kind of a first mover. And so the likelihood of having some kind of open ground for patents is probably a lot higher there. And then we start talking about, before the show, you'd asked a question about how people get in kind of on, how do you start these processes in a lean way? Because you're clearly very busy, got a lot of irons in the fire, and so a lot of people would look at this and they would say, I don't even know where to start. Like, how do I do this? But in the patent world, the thing that people should know about, well, I'll tell two, but just because I think they're important and they might apply to you. I don't know for sure, but they might. One, the first thing that you should know, or people in your position should know, is when you have these types of things, you need to know that public disclosure of the details of your invention can trigger certain things, maybe even stop you from being able to get a patent in the future. So public
don't air this video is what you're saying.
I'm not sure. I mean, you would have to be the judge of whether or not we said anything in enough detail.
But we're 30 weeks out, so I think I'll be finished by then.
Yeah. So public disclosure dates are really important. And in the US, there's something called a grace period for 12 months. So that's also a kind of a fallback position you can have. But the other thing I was going to mention is in the patent world, the place where people usually start, and there are a lot of philosophies out there, but none of them are true except this one, right? The place people start, if you want to start lean, is what's called a provisional patent application. And it's just an informal description of the important parts of your invention, and you file that with the patent office. It doesn't have all the formalities, formal drawings, patent claims, or even like formatting requirements. And so you can put these together. You can throw a cover sheet on there. You can get it filed. If you have an attorney help you with it, it's a lot less expensive because they're not having to go through the legal rigor of a formal application. And so that's where most people will start, and that will buy you a 12-month patent pending period. So people can get the patent pending status just by filing this. Now it only covers what you described. So if you don't put enough in there, or if your invention changes over the next 12 months, which is rather common too, because you're in development, right, when you file these things,